Hello, everyone. Thank you for joining us today, wherever you are. My name is Michelle Sonin, and I am the Director and Head for Northeast Asia at SIAC. We're delighted to host this webinar today in connection with the ongoing revision of the SIAC arbitration rules. The SIAC Secretariat has been hard at work, together with the SIAC Court of Arbitration, revising the SIAC Rules 2016 to take into account recent developments in international arbitration practice and procedure, with the goal of better serving our users. In August this year, SIAC issued a draft version of the 7th edition of the SIAC Rules and commenced a public consultation on the draft rules. In this webinar, SIAC Registrar and 3 members of the SIAC Court will provide insight into some of the key proposed changes. We also encourage you to share your feedback on the rules as part of the public consultation process. After discussion with the panelists, we will open the floor to Q&A. Please submit your questions through the Q&A box at the bottom of your screen. We will compile the questions and then answer as many as possible during the Q&A portion of the event webinar. Before we begin, let me take a moment to introduce our panelists. Joining us is the SIAC Registrar, Mr. Kevin Nash. Kevin leads the SIAC Secretariat in the provision of case management services, as well as the drafting of the 7th edition of the SIAC Rules. He's a wealth of experience and institutional knowledge, having worked closely on the revisions to the 2013 and 2013 versions of the SIAC Rules, as well as the SIAC Investment Arbitration Rules 2017. We also have with us 3 members of the SIAC Court of Arbitration: Ms. Jessica Fay, International Partner at King & Wood Mallesons, based in Beijing and Hong Kong; Mr. Michael Schneider, Senior Counsel at Lalive, based in Geneva; and Mr. Thomas Snyder, Partner and Head of Arbitration at Charles, Russell and Speechlys, based in Dubai. Thank you all for joining us today. To kick off, I'm going to hand the floor over to Kevin to give us a brief overview of the new rules and the running themes that appear in the rules, as well as the considerations that inform the rules revision process. Kevin?
Thanks, Michelle. It's great to be here. Maybe as a starting point, I should say the reason why the SIAC rules are good is because of our users. During the consultation process on the 2016 rules, we received nearly 1,000 comments. So we're hoping that we can match that on this edition, because we really want to make sure that we are giving effect to the needs and wants of our users. I suppose the second reason why the SIAC rules are very good is because of the 35 members of the SIAC Court of Arbitration. Certainly the SIAC Secretariat is drafting the rules, but it is ultimately the experience and wisdom of the SIAC Court that makes these rules so robust. I think the important thing when you're rule drafting is to come up with an ethos and a theme to the rules. For us, it's really on the basis of case management. I have my physical copy of the rules somewhere around here, and you will see markups on every rule, because once we are administering cases and if we see there's maybe a gap or a lacuna in the rules, we will then mark that down based on that experience on that case. And if we see this issue come up enough, then we will go to a revision. The good news is that the SIAC Rules 2016 are working quite well, but we wanted to see if we could make these rules even better. One thing that I've tried to look at during the Secretariat drafting is to make sure that we are giving effect to what users want, and we also have an elegant and accessible set of rules. So we've introduced some new provisions. Of course, we're always seeing whether or not we can make arbitration even more efficient, but the rules are also a bit akin to the case management philosophy that we have at SIAC. You want to be timely and you want to be precise. You can't have one without the other, and we're hoping that the rules will help achieve these goals. And of course, at SIAC, because we've had parties from, I think, 106 jurisdictions in the past 5 years, many different seats of arbitration, governing law, we also want to make sure that our rules work across these different jurisdictions. So these will include model law jurisdictions, but also non-model law jurisdictions as well. So that's, Michelle, a general background on the rules, but I look forward to discussing the specific provisions and hopefully hearing from everyone in attendance. I understand that we have a dedicated period for Q&A, but I think that we're all happy to take questions on each of the topics as we cover them.
Absolutely. Thanks so much, Kevin. That's great. Now that we've got the sort of overview of the running themes, let's dive into some of the proposed changes. We can start with one of the most talked about proposed additions to the new rules. It's called the streamlined procedure in proposed Rule 13. Perhaps if expedited procedure is a fast track, then we can call this the lightning track procedure. Kevin, can I throw it back to you to tell us about this streamlined procedure and how it works and what the rationale was behind it?
Michelle, I think that we're still in the market for a name that might be better than streamlined procedure. So lightning procedure, I have a colleague that is very committed to calling it flash procedure. But I guess the general background subject to the preferred nomenclature is that we wanted to have a procedure that was even faster for those relatively simple, lower value disputes. Now, we're always mindful that quantum does not necessarily correlate to complexity, and we have to think about how this streamlined lightning or flash procedure is going to sit beside the expedited procedure, beside preliminary determination, and also beside early dismissal. So basically, we've constructed it in a similar way to the expedited procedure. You can apply on one of three bases. So based on the amount in dispute, we've looked at under 1 million Singapore dollars on the basis of party agreement, or the third new category, which we've received a lot of conversation about, that the circumstances of the case would warrant the application of the streamlined procedure. We've also given tribunals more procedural discretion under the streamlined procedure. So the idea is that this would be docs only unless the tribunal decides otherwise, and the tribunal is able to limit requests for instance, document production. It also is a series of threes. So the award is made 3 months from the constitution of the tribunal. The appointment is made in 3 days if the parties can't jointly agree on the nomination of a sole arbitrator, and that is a default sole arbitrator. But one thing that people have been quite excited about is the fact that it will be 50% of the maximum fee caps under the schedule of fees. So this will apply both to tribunal fees and also SIAC's administration fees. So this will be a very cost-effective procedure. And we're also cognizant that we are, to a certain degree, auditioning for new users, access to justice, being able to get involved in an SIAC arbitration without a very heavy price. So I think lots to talk about on the streamlined procedure. And Michelle, I will pass it back to you, and hopefully my betters on the SIAC court can provide some of their insight.
Thanks, Kevin. Thanks for tossing it back to me, but now I'm going to toss it to someone else. I'm going to invite Tom to share his views on the procedure and whether, in your view, this would be a welcome change to have this lightning flash, speedy resolution of disputes.
Great, thank you very much, and hello everyone. It's a real pleasure to take part in this discussion today. Look, I have to say, on balance, I like the streamlined procedure. I think it's yet another example of SIAC sort of being innovative and pushing the envelope and getting parties and users and counsel and other institutions to think about ways that the arbitral process can be improved. You know, if you step back, you could say, look, parties can exercise autonomy. Tribunals have the inherent authority to conduct the proceedings in the manner that they see fit. And, you know, if they see fit to conclude a proceeding in 3 months, they can do so. They don't need particular provisions to do that. But I think my answer to that is that frequently, when parties are in dispute, it gets hard to sort of push them in that direction of efficiency. And I think having a framework for parties and tribunals to accomplish that is really important. And I think having multiple frameworks is really important. I like the idea It's not the case that one size fits all. There's the, whatever you want to call it, the standard provisions, there's the expedited procedures, and now there'll be the streamlined procedures. And I think having those different categories can be very, very helpful. I think Kevin's done a good job of summarizing it already. I think he hit the key point that it's hard to, ex ante figure out where a dispute lies. These thresholds may not always work. There may be very complicated disputes where the amount dispute is under $1 million Singapore dollars, but I think that's a good starting point. Obviously, party agreement. The third prong, circumstances of the case warrant the application of the streamlined procedures. This, of course, applies as well in the expedited procedures, which I think we'll talk a little bit about later. That does give quite a level of discretion to the registrar. I think if that provision stays in, as long as it's used sparingly, it probably won't create any issues. It probably sits better with expedited procedures than it does streamlined procedures. But I do think it's a better standard than the existing one, which I think is exceptional in cases of exceptional urgency. Streamlined procedures and expedited procedures are about efficiency, but not necessarily urgency. So I think this little bit broader standard works well.
Thanks, Tom. If I could come back to that third ground, and I'll just repeat the language. So it allows for an application to streamline procedure when the circumstances of the case warrant the application of the streamlined procedure. And I understand we've got some feedback in other sessions that this language is too broad, that it does give the president too much discretion, and that provides parties with some level of uncertainty. Do you have any thoughts on that view, or I can also open this up to Michael, Kevin, Jessica to chime in?
Perhaps one of the concerns I would have is to have a streamline in our discussion at UNCITRAL, the supersonic arbitration was a proposal as a term. For that procedure to occur without the agreement of both parties in the arbitration clause or elsewhere, I find that problematic, because especially from the perspective of how we're doing arbitration now, I think basically it is useful to have this possibility, and it's a stripped down procedure, but it really requires or implies a lot of shortcuts and a lot of cutting what parties normally do in arbitration. And to have it without the agreement of both parties and simply by reference to an amount, I find that problematic. And then to have if the circumstances justify that procedure, the parties could agree on it. If they haven't agreed, then that the court can impose at the request, of course, of the claimant. I find that problematic.
Thanks, Michael. Jessica, I saw you take your mute off.
Yeah, if I may, actually, I'm very much in favor of having a more efficiency related design for the rules. Actually, I just spoke on these streamlined procedures and expedited procedures, in Shenzhen on the SIAC seminar. Because for us as practitioner, although I fully agree with Michael, very often parties are, sometimes the purpose or objective is more on whether you have all the due process and have the proper process and have the right results. But for disputes where the amount in dispute is not so significant in international arbitration, that has always been a real concern of practitioners and users. For example, with the amount less than 1 million Singapore dollars, actually, they will have to calculate the potential expense of the tribunal, of institution, and of counsel, which can easily go beyond the total amount in dispute. And from users' perspective, that would be very hard to justify, unless, for example, on top of the limited amount, there is something more significant of a issue of principle, then I think I agree that probably wouldn't apply the, which should not be considered for the so-called streamlined procedure, but maybe a more kind of normal or general procedure. But for smaller disputes, even if a disputed issue could be a little complex, but I think for efficiency and also for the eventual benefits of the users of dispute resolution service, that is, I think, a very positive move. I would be, I think as practitioner, now I have a better tool to go to my client saying, look, you can still pursue a $500,000 dispute with, like we just say, lightning speed and have a result. That's probably, even if there is any risk of the final outcome, I think that's something probably can overweigh the extensive cost and time for resolving the relatively smaller disputes.
Mm-hmm. Would you be in favor of having this provision actually automatically apply once the monetary threshold is met? So for the viewers, the threshold is 1 million Singapore dollars, which is about at today's exchange rate, $750,000 US.
Yes, if, as I mentioned, if there is no other factors that may complicate the disputes, then I think just for an amount less than 1 million, I would be happy to, to have an automatic application because of its limited amount. In terms of compared to the legal expense, that is something I think we do need to consider to design something to suit the customer's needs.
Mm-hmm, mm-hmm. And
And you would do that without the agreement of the parties, of both parties.
If I think that's the approach of SIAC rules and, for example, other institutional rules, where you have agreed to these rules, you are deemed to have accepted and agreed to the provisions of these rules, unless you expressly exclude the application. I think that would be the kind of the general approach.
But that is the general approach to, let's say, expedited proceedings, which still have a minimum of, let's say, due process. In the streamlined procedure, you really have it stripped out a lot. And the question is, do you do that without the agreement of the parties?
I
in
think
fact,
even
one of the things we were discussing in UNCITRAL was to have there where it's through a model clause, an introduction which highlights the risks that the parties go into from the due process procedure, and that if we do an automatic application, that wouldn't be there.
Mm-hmm.
And of course, for the arbitrator too, because the arbitrator has to be very rigorous with the parties and impose on them. And that's the other point, especially on the respondent. If the arbitrator can say, well, you've agreed to it, it's a different thing that if it's in the rules. And I think Jessica is right. We have this type of provision on other procedures, but we're satisfied that in the expedited proceeding, both parties can adequately be heard, where the question is, can this be done in the streamlined procedure, especially with the restriction?
Mm-hmm.
Yeah. I have another point on documents only, but that before we close, I think I'd like to say that
sure.
I think we're at a different issue now.
I was actually going to go into unless anyone else has further comments on this point, I think your comment led nicely into the documents only issue. And so for the benefit of our viewers, by default, the streamlined procedure is if documents only, meaning that the arbitration would proceed based just on the papers, there wouldn't be a hearing. And then also without any document production. This is by default. Of course, the tribunal can decide otherwise based on the circumstances of the case. So Michael, sure, please go ahead and let us know your views.
from my perspective, and of course I have my own way of running an arbitration, it is very interactive, and I find it very useful to discuss with the parties. And the shorter the time available, I think the more useful it is to clarify the situation. Therefore, of course, the rules say the arbitrator may decide to have a hearing. But it is always only a fallback position, and I think we shouldn't underestimate the usefulness, especially in a very short period, of the arbitrator discussing with the parties what the issues are and what has to be addressed. So I wonder whether we should make this as a fallback position, or that documents only would be the fallback position, rather than a decision which the arbitrator can decide.
Sure. Anybody have thoughts on that?
I think well, one thing I would note is that sort of the other default position is no fact or expert witnesses either. I mean, I think my view is I'm relatively comfortable with this because it is only a default position. And I think when you get into practice, there'll be some give and take here. I think the tribunals will assess the situation. You know, if a respondent comes in and says, I've got 6 fact witnesses and an expert report I want to file, that may be one thing. But if it's one fact witness on a discrete issue and we need a 30-minute hearing for cross-examination, I can see that working in a 3-month period. So I'm comfortable with the default.
Can I just clarify the point? My concern is not so much the evidence, that is an additional problem. My concern is parties, and especially a respondent who in the short time has not thought through, has not covered everything that is or is not clear. And in international arbitration, the type of submissions you find may be surprising, and especially in such a short period, that especially the respondent hasn't addressed all the points and hasn't been really fully or hasn't been clear. So from my perspective, sitting with the parties, even in a few hours, to clarify what is the issue, especially if you have very little time, I find this very useful. Of course, Tom, you're right. It is a fallback position. The question is, what message do we send? And I think, especially in international arbitration, where you have parties with very different backgrounds, a fallback position, or the message that you should do it on documents only, I find that a bit problematic.
There is still a requirement. I think it's stated in mandatory language that there be a case management conference at the outset. Now, you're right, that will take place just a few days after the tribunal is constituted. But even with a default of no hearing, I can't see why the tribunal couldn't hold multiple case management conferences to address some of these issues during this time period and sort of engage with the parties to make sure they stay on track.
They can. I'm not questioning. The question is, what message do we send in the rules by having one approach as a default position rather than another? That's you're quite right. The tribunal can, but if you have in the rules the normal position is documents only, that's the message, and the tribunal will have to say, well, I have to justify why. And especially since in the discussion now, there is so much emphasis on the possibility of doing things documents only. And that may be something in a shipping dispute or a commodity dispute, but we don't know what type of dispute is coming up.
And then Michael, I suppose the challenge is, does this satisfy Article 24 sub 1 of the model law? So subject to any contrary agreement by the parties in the case where you have a contested application. I think that it would be a very robust tribunal that probably wouldn't end up having a hearing because the language in the streamlined procedure, unless the tribunal decides otherwise. So to a certain degree, I think if that request was made, even under the streamlined procedure, the tribunal would probably have it. This goes to that old issue of an express agreement versus an incorporated term. What is going to govern there? So I think in practice, I think that would probably work. And Tom, to your point, and this is not always readily available a couple weeks into a proceeding where the president would have to decide on the streamlined procedure. If there was a lot of fact or expert evidence, I imagine that the party contesting the application of the streamlined procedure would say, hey, we are going to have all of these fact witnesses. We don't think it would be appropriate. And then it wouldn't end up being granted.
Thank you all for that really robust discussion. I think there's a lot of room for discussion with respect to streamline or lightning or supersonic procedure, whatever you want to call it. And we can come back to that in the Q&A session. Let's move on to what may be called the cousin of a streamlined procedure, the expedited procedure. So of course, there have been many comparisons between the two, and expedited procedure is one of SIAC's most popular special procedures. We've now received nearly 900 applications since introducing the procedure in 2010, and of those, SIAC has granted 60%. So certainly Kevin had his work cut out for him when he tried to update he and the court had tried to update one of the SIAC's most beloved features. So we already talked about quite a bit with respect to streamline, but can you introduce some of the key changes here and I understand there's also some overlap in the language in streamline as well as expedited.
Thanks, Michelle. Maybe this is a good time to discuss why we included that the circumstances of the case would warrant this time the application of the expedited procedure, and we may be moving away from that in the streamlined procedure, but effectively that's to allow a very simple case that might be 100 million USD, but that we think is appropriate for the expedited procedure. I know that Tom and I have been around the world. It seems like we always end up being on a fast track panel, and I've always said that I still don't entirely understand what exceptional urgency is. After having administered almost 900 applications for the expedited procedure, I have seen maybe 2 or 3 successful applications on the basis of exceptional urgency. So we wanted to make that third category broader, under which exceptional urgency could also be argued. Or a party could say that this is a very simple case, it's $100 million, but this turns on one discrete issue, and we think would be appropriate for the expedited procedure. Of course, these are contested applications. Even sometimes party agreement can be difficult to discern. And I use the example of an arbitration clause that's not an expedited procedure model clause, but it says language to the effect the parties agree that the arbitration should be conducted expeditiously. And an ambitious party takes that language to say that the parties already agree on the expedited procedure. President, please decide. Besides this application, the procedure is largely similar. I think one interesting provision that we've added is if there is a hearing, the default is a virtual hearing rather than an in-person hearing, but there's still that discretion there. We've softened the language somewhat on a party requesting a hearing, again, cognizant of the provisions in the various lex arbitrii around the world that a party may request a hearing. So the expedited procedure is working well. We chose the sum and dispute limit or the ceiling of 10 million Singapore dollars. I'd be interested from the court members and from the attendees. Is this the right amount? And I can tell you when we were looking at it, we were looking at the overall profile of SIAC's cases, thousands of cases, and then nearly 1,000 applications for expedited procedure. But really that $10 million is when parties tend to start going to a 3-member tribunal rather than a sole arbitrator tribunal. I think importantly under the expedited procedure, we have the option of expedited procedure before a sole arbitrator or before a 3-member tribunal, whereas under the streamlined procedure, it's default sole arbitrator and doesn't have that flexibility. One thing that I think I should note is that even if this provision is very broad, that is kind of a theme of the SIAC rules, that we want to have broad, usable provisions, but then we want to be able to exercise the discretion. And all of these categories to apply for the expedited procedure, this does not mean that you automatically get the expedited procedure. And it's actually less than 60% of the applications that end up being successful. And it's kind of an old joke in arbitration right now, is that the moving party that wants to apply says this is a very simple case. And then the resisting party says, no, this is much more complex than it first appears. And the challenge for the institution is we have to decide all of this in a few weeks, perhaps just with a relatively bare request for arbitration and a response to the request for arbitration.
Thanks, Kevin. So I'll have invite Jessica to start off the discussion on this one. Any views on some of the proposed changes?
As I mentioned just now, like I think this expedited procedure was already in the rules, have been in the rules for a while. And this round for consultation of the amendments, I think SIAC is considering adding an extra layer, which we just discussed, called streamlined procedure. And I think on that basis, to consider to adjust the amount of dispute for consideration to apply the so-called expedite procedure is actually quite sensible, because sometimes, I think in the past, when you just have about, let's say, around 5 million Singapore dollars, that is still less than 1 million US. As we all know, as practitioners, 1 million US dollar case, around that amount actually is kind of tricky. That could be still a hard decision as to how would you tell your client how to justify the legal expense versus the potential outcome, etc. So I think, although no one can really say which number is the absolutely right number for the threshold, but I think around 10 million, which is just slightly below like 2 million US, is probably about right for considering the so-called either kind of in arbitration summary procedure or expedite procedure, and use many of the mechanisms to limit the time and costs of arbitration. I think those actually I understand why SIAC is so concerned of these kind of having more efficient procedure, is to take into consideration the users' expectations and also complaints on the costs and time for conducting international arbitration. Because clearly everyone would probably agree, for a matter of 10 million Singapore dollars or less than 10 million Singapore dollars compared to a 10 million US dollar case, is actually 1 billion, let's say, is definitely the clients would invest different, like in legal fees. So in view of that, and also there are so many smaller or smallish cases where I think clients, it's not just about the legal expense, legal fees would be a huge concern, but also the time. So I think to try to strike a balance, to have expedited procedure to apply to relatively smallish cases with a quicker track procedures. I think that actually the objective is more on efficiency and also to answer, I think, the users or clients' needs for quicker dispute resolution, because many of the disputes, just as we all agree, unless it is provided, has already been agreed in the arbitration clause and or specified in the arbitration rules, once a dispute arises, you'll probably be very hard to get any agreement from the respondent on having anything quicker. Or, they will always try to complicate the proceedings, although sometimes it might be right, because claimant wants to make the case look more straightforward and have a quicker decision. But respondent might be right to say, no, that's not right. So it could be both cases, could be the respondent wants to make it complicated for the purpose of making it complicated, or there are other like real issues that was not disclosed by the claimant side. So it can be either way. But I think to strike a balance, to set a kind of benchmark for considering expedite procedure, and of course also built in the mechanism enough room for parties' agreement and discretion by SIAC. I think that is a very welcome measure that, at least from my perspective, and also speaking from the perspective of many Chinese and Asian users who are very concerned of the time and costs. I think that's actually is a welcome measure that I would want to advocate to my clients to accept, and also as part of the reason to consider SIAC as the preferred arbitration institution.
Thanks, Jessica. May I, let's focus a little bit on what Kevin mentioned, is that effectively the proposed rule would mandate a virtual hearing as opposed to a hearing in person. And I'm curious if that little tweak has raised any of your eyebrows as to whether it's a welcome change, or and how you might deal with a party that would prefer to have in person.
I think the default to have a virtual hearing is probably acceptable because of the amount in dispute is somewhat limited, as we know. For a physical hearing, if we need to fly everyone to Singapore for the hearing, that itself actually could be costly. So unless I think parties really insist, and if there is a one or two particular factual witness that will need very careful examination, which may make physical hearing more useful. And I think parties should have the liberty to apply and to consider whether that will be, or having some kind of hybrid hearing if, circumstances, I think, would warrant such application. I think the tribunal should consider. I'm sure, as Kevin mentioned, always the rules have, certain rules will allow room for the tribunal and for the parties to apply for something different from the default. Yeah. But generally, I think I don't really have big concern over virtual hearing, because that has been the reality for the past 3 years, even for bigger cases.
Kevin, can I ask you on the language of the rule? Is my understanding correct? So it says the tribunal shall hold any video conference, teleconference, or other form of electronic communication unless the parties agree to an in-person or hybrid hearing. So does that mean that both parties would have to agree? The tribunal can't decide to have in-person when just one party requests it?
Yeah, that could merit unless the tribunal determines otherwise, but sometimes just from a drafting standpoint, that starts to become a bit unwieldy. Obviously, this is a conversation between the parties and the tribunal. I think that we all owe a big debt to gratitude to the ICA guides on whether or not there's an express or an implied right to an in-person hearing. I think early during COVID, I had actually told ICA that I probably visit that web page more than anyone else, because you would want to see on the various jurisdictions. So I think that maybe some revision to the language, because most times you'd be expecting that one side would be saying we need an in-person hearing, another side would be saying, as per the language of the rules, a virtual hearing is okay. But does the tribunal still have discretion after that? I think it ought to have that discretion based on the circumstances of the case.
Sure. I mean, you might have oh, sorry, go ahead.
I was just going to say, I think with that safety valve that Kevin was just discussing, I'd be very comfortable with this provision, this requirement of a default of a video conference and expedited proceedings.
With respect to hybrid proceedings, the experience I've made is that even if you have a virtual hearing and different witnesses and experts at different places, I would like to have the tribunal together. Because it makes so much difference. Even, electronically, you can move to an electronic breakout room, but that's not the same thing than if you sit the three of us together. Even to kicking each other under the table. Is there a problem the way how you formulate it now with respect to hybrid hearings? Of course, you would have normally a sole arbitrator, but if you have three, which is a possibility, that would be a concern of mine.
Yeah, and you certainly wouldn't want any sort of inequality of arms where you had two arbitrators were present in person. Exactly. And then the third arbitrator. So yeah, I think that how we've dealt with a hybrid hearing, I think, would need to be revised. And I guess maybe as a larger point, and Tom kind of indicated this, sometimes what we're doing here, even if the tribunal has discretion, is creating what a general view of the institution is going to be. When you have the expedited procedure, that generally this is going to be a virtual hearing unless there are circumstances. So we're just trying to create that mindset. And to Jessica's point, because there is quite a cost savings if you don't have to fly everyone for a hearing. But Michael, certainly, and we've had quite a few of those situations, actually, to the point where we had a 3-member tribunal. Presiding arbitrator was based in Singapore, and so was one of the co-arbitrators. The other co-arbitrator was in Europe. So even the Singapore-based co-arbitrator participated virtually because it wouldn't have been fair to have 2 of the arbitrators in person and 1 participating remotely.
And the parties would be feeling very uneasy.
I think so, yeah, for sure.
The other party, the one whose arbitrator is not present.
Yeah.
Kevin, I like the defaults that are sort of being set up here. If you take a step back and look at it, you know, streamlined procedure, the default is no hearing, expedited, it's virtual hearing, regular proceedings, it doesn't say this, but most likely a merits hearing, or, you know, whatever the parties in tribunal decide. Kevin, I had a question for you. I assume this is the case, but if you've got a dispute, if you've got an arbitration where the amount dispute is 800,000 Singapore dollars, I assume a party would be at liberty to apply for either streamlined or expedited proceedings. Is that correct?
Yeah, that's the way that it's formulated. But I think that we have to think about how this is actually going to work in practice. So if you have, likely the higher bar to surpass would be the streamlined procedure. So will you have a situation where a party first applies for the streamlined procedure, is unsuccessful, and then it's like, oh, okay, now we're going to apply for the expedited procedure? Or should it be effectively a one shot? So we still have to do some tweaks there to see how this is going to work.
Or an application for streamlined with expedited procedures in the alternative.
Yeah, I think so, because we're so experienced at administering under the expedited procedure. So an application for expedited procedure, we've done it so many times, we can process it so quickly. But introducing this new wrinkle of this additional procedure that sits side by side, that is something that we have to turn our mind to. I think that, as you say, an alternative argument or a separate application, I think, should be allowable. I don't think you should be precluded by virtue of choosing the streamlined procedure first, or the other way around, that then you no longer have access to this. But we also are cognizant of the time that it will take. You don't want to have too many procedural applications, because you don't have the provision, say, on joinder and consolidation, or likely will be applicable in the streamlined procedure joinder in any event. But if you failed in an application for streamlined procedure and now you have the expedited procedure, that could be followed by various procedural applications which are not allowable under the streamlined procedure. So that could take some time, and now you may end up say a month or 6 weeks after the commencement of the arbitration, and you're still trying to determine the procedure to apply.
Yeah, Kevin, I think just in practice, I guess, because now we are looking at potentially 3 different proceedings to deal with one application. So there might be other kind of procedural nuances. For example, if the original application is within the threshold, and then the counterclaim comes, and then whether there will be any modification to the claims or counterclaims, whether the procedure should be adjusted. So I think that's something, mechanical that or procedurally we need to maybe have, going forward, have some kind of procedural guidelines, so that there won't be too much kind of switch up and down. Because if the amount, the benchmark is a real issue, then actually I can design my claim to be either below or slightly above.
Or what about that poor party that has a claim that is $1,001 that doesn't get the 50% discount? So the $1 more on the claim, and they're no longer eligible if they don't use that limb to get under the streamlined procedure. I think that's one of the reasons why I like circumstances would warrant the application of the expedited procedure. We'll see about the streamlined procedure, because it prevents a party being able to thwart an application by virtue of an unmeritorious counterclaim. So if you are just basing it on the sum and dispute, and you have a claimant that's applying for the expedited procedure, $5 million claim, and then the respondent says, well, we have a $10 million counterclaim, this is no longer suitable for the expedited procedure. And then somewhere midstream, they then withdraw this counterclaim that they never had an intention to pursue. So I think we're used to dealing with that situation under the expedited procedure, but the catch-all category, I think, is helpful for that, not immediately thwarted by going $1 over the maximum.
Yeah, I can see why people are uncomfortable with that, but I think it's important for the SIAC to maintain a little bit of discretion there for the reasons you just mentioned.
Well, thanks, everyone. We should get moving to our next topic, although I think...
Can I just, one point I wanted to, that probably applies to both. In the streamlined procedure, you have that the case management conference is only for the timetable. I think that should be broader. And I think what Tom mentioned before, that questions between the parties and the tribunal that should be can be dealt with without having to call this a hearing. Much depends on what you call a hearing, but that should be broader, and I think that applies for expedited proceedings too. And then the other point of interlocutory applications, what would you want to have unlimited scope for interlocutory applications, including interim measures? Even with a 3-month procedure, you may need you need special measures for urgent points. And do you want to allow that in either the expedited and in the streamlined procedure? Sorry to have come back with a point that
No, thank you, Michael. Those are.
I hope I haven't upset the procedural timetable for our meeting.
Absolutely not. Absolutely not.
Michelle, they're the fastest procedures, but they also always take the most time to discuss expedited.
Yes. Very much talked about. Okay, let's move on to another very controversial. Well, when it was started first proposed into international arbitration, but was controversial, was the emergency arbitration. But that's now been a feature of the SIAC rules for many years, and we've developed expertise in the administration of emergency arbitration. But the draft rules have proposed a couple of changes to the way the emergency arbitration would be run, and I will hand this over to Kevin to share some of those, and then we'll discuss those as well.
I will try to be a bit more expedited on this. Of course, emergency arbitration has become a standard feature of international arbitration. Of course, Singapore updated its legislation to provide for the enforceability of emergency arbitrator orders and awards. So it's working well. I think that we've had around 150 of these applications. There's also always the question of whether or not you can go to court. I really like the language of the Singapore International Arbitration Act that allows you to go to court, say if you needed an order against a third party ex parte relief. I will say within the walls of the Secretariat, and we've probably been discussing this for 10 years, is the possibility of an ex parte application for the appointment of an emergency arbitrator, and likely then what would happen is a preliminary order, and then the party would be notified. So we're looking at that. The big change we have in this schedule is that you are now allowed to make an application for the appointment of an emergency arbitrator prior to the filing of the notice of arbitration. So really, this is just a fine tuning of a procedure that's also already working very well.
May I ask you or Michael to share his views on what the benefit would be of being able to file the emergency arbitration before the notice? Why is that change necessary?
Kevin, you want to answer it? I find it absolutely necessary, especially the time, if the urgent situation arises, the time you want to have for preparing your request for arbitration, especially with the consequences that has for the rest of the arbitration. If you, it really makes a difference if you get it the right angle in the notice of arbitration. So I think it's an absolute necessity. What is interesting in this procedure is that years ago, the ICC started what was called the pre-arbitral referee. and it wasn't successful at all. There were just a few cases. And suddenly somebody, I think the Swedes, came up with the emergency arbitrator, and now it has been a general practice, and as Kevin just explained, it's frequently referred to. So it may be interesting for us to think about how procedural measures become suddenly a need is perceived, and now everybody has it.
Yeah, I think it was to be fair and give credit where credit is due. I think it was ICDR in 2006. So ICC pre-arbitral referee in 92, ICDR in 2006, then SIC.
I don't know. It was not the Swedes.
Stockholm was also 2010. So Stockholm and SIC 2010. The fact that I know is somewhat disturbing, that I'm always reading about the history of emergency arbitration, but we'll leave that for another day.
It shows the broad knowledge and experience of Kevin.
Yes. To your point, Michael, of that sometimes parties would require more time to have a fully thought out notice of arbitration. I saw in the proposed rules that the notice would be required within 5 days of filing the emergency. Is that enough time? You think that is
another point I noted. I wonder why we need the filing of the arbitration, of the notice of arbitration. It is in order not to have this hanging in the air. But if you have the notice of arbitration during the procedure of the emergency arbitrator, that should be enough. I'm not sure that these 5 days, other rules don't have such a short period. I think we'll have to really think why during the emergency arbitrator proceedings there should be a notice of arbitration, and whether that is really requires the same short periods we have in the emergency arbitrator proceedings. So I think 5 days is too short. We just want to make sure that the emergency proceedings don't hang in the air. It is also, there's one thing where the emergency arbitrator may want to see what the actual arbitration is in order to see what's the relationship. And something which I find a bit surprising is that neither in the emergency arbitrator procedure nor in the procedure for interim measures is there any description of what type of measures are the scope of these applications. And in some legal systems, and in the German and French and most of the continental system, there is a relationship of the interim measures, or where we don't have in the court proceedings the emergency arbitrator because you get the interim measures, but the relationship between the interim measures and the application, or the application for interim measures. And the question is there a need of having a relationship? And then if there is such a need, which is not specified now, there would be an interest in having, for the emergency arbitrator, seeing at an early stage the notice for arbitration. Did you have ever in your application of the emergency arbitrator or interim measures any debate of whether the measure is admissible?
We have had some debate. So you have, I mean, I think that it's helpful in a Singapore seated arbitration and then the SIAC rules, because you have an articulation of the powers of a tribunal. So the emergency arbitrator can grant all the reliefs that the tribunal can grant, that is then specified in the Singapore legislation and under
the Singapore legislation. Because in the rules there's nothing.
So you have the powers of the tribunal, which the emergency arbitrator shares. But that's a non-exhaustive list of the powers of the tribunal.
Does it really refer to it? I checked that. I didn't find the reference of the emergency arbitrator to the powers of the tribunal for interim measures. There is
yes.
There is something, but it doesn't refer to the powers.
This is
I think
how to order or award any interim relief that the emergency arbitrator deems necessary.
Which one
In
is
paragraph
that?
17 of Schedule 1.
17? Let me just check.
so, and then paragraph 13, all the powers vested in the tribunal.
Yeah.
This is a great exercise in understanding the decision-making that goes into the rules and the sort of referencing back and forth between the statutes, the current rules, what's proposed in the new rules. Perhaps, Michael, if okay with you, perhaps we move on to the next question. We come back to this?
Yes.
Great.
Now, that also has consequences on these 5 days with the change you're making, but also I wonder the application, what is in the application now, for instance, that you have to put documents as if it was before a tribunal that doesn't have the application for emergency arbitrator. I think that should be tweaked. That may be necessary if there is no notice for arbitration, but if there is a notice for arbitration, I think you can simplify the requirements. But Kevin, you're better placed to know the problems or whether necessary, because the way how it is now, if you have a notice for arbitration already at the center and the other party, then some of the points in the application seem unnecessary. And I think you would have to distinguish now in the application between the situation where the application is made before the notice is filed, and if it is filed already, then you can simplify that. The time, 10 days, I think is a short period, and the emergency arbitrator proceedings, which I have seen, there was more time. And I wonder whether in situations like this, you could have a more flexible way of formulating it, saying with in view of the urgency or something very urgent, but at a maximum 10 days, so as to give the measure to that the emergency arbitrator has an interest in getting that through earlier, and have perhaps instead of 10 days, let's say 2 weeks or something a bit longer, but then saying this is the outer limit, rather than having it as a simple a clear date. Because if you have 10 days or a fixed number, you will plan the emergency arbit procedure within that period. And if you say it's the outer limit, that can expand modified only in exceptional circumstances by the court or the registrar.
Yeah, I think
we took that down. We took that down from 14 days, and we have gotten some feedback that suggested this is a bit too fast. We selected 10 days on the basis of the average amount of time that emergency arbitration proceedings would take, which was less than 10 days. But we also have to be cognizant, Michael, particularly if we take your suggestion, to which I agree, that it shouldn't be 5 days for the filing of the notice, that then there's going to be some time built in there after, say, if the notice comes after the emergency arbitrator renders his or her decision, or somewhere a bit further down the line. Because I think one way that what you want to do as an institution is you want to be running the main arbitration in parallel, particularly if it's a 3-member tribunal. So you've got the emergency arbitration happening on the one hand, but then you're also confirming co-arbitrators on the other hand, so that everything is ready to go. And then if a party wants to make an application to vacate or modify, that tribunal is constituted almost immediately, and then you're now in the main arbitration. So we have to be a bit cognizant of that. I think 10 days, Michael, as you say, might be a bit too short, or it needs to be clarified.
You mentioned the relationship to the main arbitration. There again, I wonder whether it is desirable to have the provision that the emergency arbitrator has no powers after the constitution of the tribunal. If you imagine Probably depending on how long it takes to set up the tribunal, especially if the respondent should appoint an arbitrator, probably the procedure is over, the emergency arbitrating procedure is over. But if not, halfway through, the way how it's formulated now, the arbitrator should drop his pen, the emergency arbitrator should drop his pen, and you don't, it's hanging in the air. And other rules I've checked with the ICC, that they don't have this provision, and I think that should be reconsidered, whether once the tribunal is considered, the emergency arbitration proceedings is interrupted, because the tribunal will still take some time, especially if it's a 3-member tribunal, to get a grip on the procedure. And you would add then, in an urgent situation, you would add then the time that the tribunal needs to understand the case and be comfortable with ordering interim measures. So I think that I find this problematic. This clause, I think, forgot what clause it is, to say the power will end with the constitution of the tribunal. The other point I have is order or award. You have a procedure, you provide in the procedure that the emergency arbitrator can modify. So in 10 or 15 days, you have 2 different decisions, and they should all be awards. I mean, it was an idea of somebody, I think, in the ICC rules, who introduced this idea that you can make interim measures in an award. I find this problematic, especially if you have a separate procedure, and the point of emergency arbitrator decision is that it's flexible and can be modified. And to have this in the form of an award, I find this quite problematic. But I don't know whether there can be anything can be done about that.
That is an excellent point, and we probably need a better answer than substance over form to get there. Because how are you modifying an award thereafter?
Thanks so much, Kevin and Michael. I think you brought up some really good points, Michael, that we can think about as we continue to work on the rules. I see that one of the attendees has a hand up. May I ask you to, if you have a question, may I ask you to submit it through the Q&A box? You'll see a Q&A option at the bottom of your screen. And in just a couple minutes, we will turn to the Q&A the questions that's been posed by the attendees. Before that, let me move on to another important rule that's used very often by parties, and that is consolidation. Consolidation has been a feature of the SIAC rules for many years. And there's now a new proposed rule on something called coordinated proceedings. And these two are related. And so I will let Kevin discuss the changes to consolidation, and then share the updates with respect to the proposed coordinated proceedings rule. And then we'll have a bit of discussion on those two.
So mindful of the time, I might just pass to Tom to discuss consolidation and coordinated proceedings. What I would say is that these proceedings are working very, very well. What we particularly find is because under the SIAC rules, you don't require identity of the parties, so you don't have the same parties, which is part of the reason why I think that SIAC is being included in some of those big mega projects and giga projects, because it's a bit more broad. But I'll let Tom discuss the fine points of these updates.
Sure. So, I think that's right. And I think the key change here in relation to consolidation is to make the scope even broader. I think the key addition is in 16.1c sub 4. You also see it in 16.9 c sub 4, and that is the ability to consolidate cases where the arbitration agreements are compatible, where there's a common question of law or fact arising out of or in connection with all the arbitrations. And I think, and Kevin will correct me if I'm wrong, but I think sort of the purpose of this proposed amendment is to allow for, let's say, class action arbitrations, where you may have numerous arbitration agreements between different parties that have this common question of law or fact. I'm still trying to figure out how I feel about this. I think on one hand, again, it's an important innovation. It's broadening the scope. It's trying to make arbitration work for more and more cases. I think it could get a bit unwieldy. What gives me a little bit of confidence, though, is that the common question of law or fact language appears not just in the provision on consolidation, but in the provision on coordinated proceedings as well. Now, once again, you can say, you can query, you can ask the question, do the rules really need a provision on coordinated proceedings? I think we see coordinated proceedings happen in a variety of cases, but to me, it works because it's another example of sort of nudging tribunals and parties in a particular direction, making things more efficient. So I personally like seeing the coordinated proceedings provision appear in the rules, and I'm much more comfortable with the concept of cases being coordinated where there is a common question of law or fact. I think when you're talking about consolidation and actually consolidating these cases into one case where there could be one award, that may be pushing the envelope just a bit, but I like how it works in the coordinated proceedings.
Thanks, Tom. One thing that was pointed out is that the language in Rule 16, which allows for 2 or more arbitrations pending under SIAC's arbitration, under SIAC's administration, meaning you could consolidate 2 arbitrations under different sets of rules. And maybe this is maybe a question for Kevin from an administrative standpoint. How would that work when you've got conflicts between 2 different sets of rules in a consolidated case?
So it opens up the possibility. We have seen these applications before. So I think something for the SIAC court to consider. So for instance, it would not work if there was an application under the 2024 rules and the 2013 rules that are silent on consolidation, but could it potentially work under the 2016 rules and the 2024 rules? Maybe. I guess it's similar to the fact that I think generally it's thought in consolidation that you could have different governing laws which apply to each contract that are consolidated if they have the necessary connecting factors, but you could not have different seats of arbitration. So that would ultimately, I guess, be for the SIAC court to decide, or to the tribunal if the application is made to the tribunal. But we have the SIAC court right here. Maybe they can tell us if this is something that they would allow in a pre-constitution application for consolidation.
I think if you're expanding it, the broader it is, the more difficult it will be for the tribunal to handle. And Tom said 1 award, that may be the solution, but I think you should flag the possibility of the tribunal of having several awards and treating it separately. I have now since long a case pending where in a different institution, 2 arbitrations have been, the same tribunal has been appointed, and we're running it in parallel for some issues where we have the same issues, but they're not all the same. So we had partial awards way through, and then when we finished with one issue that was easier, it was a bit problematic of then how to separate the arbitrations, because you have consolidated the 2 cases, and then the tribunal decided one in a final manner and continued with the other, which had additional complex issues, because what you're saying, the common questions, that doesn't mean that all the questions are common. You may have common questions, let's say the validity of the agreement, and then you have different issues. So how, as a tribunal, you handle that without splitting the procedure? And what have you gained if you then split the procedure?
Great, thank you, Michael. I'm conscious that we're running low on time, so I think what I'd like to do here, if the panelists don't mind, is turn to some of the questions that have been posed by the audience. Trying to sort of organize this in the way that we had the discussion, maybe I'll start by asking, one of the participants is asking if it would be better to have a model clause that mirrors the streamlined procedure, and even mentions the threshold amount which would apply. And presumably this person means in the arbitration agreement. Any views on whether that might be workable? And I think that would be addressing Michael.
Well, that's what we're doing in UNCITRAL. We have it in UNCITRAL, it's in the model clause.
And you actually do lay out the whole procedure in the arbitration clause?
Yeah, it's a bit over a page.
Okay, wow.
But because it is still patterned on expedited proceedings, and that's what Jessica mentioned. It simply reduces certain aspects, so that makes it relatively simple. But that would limit it to what I said, that you have the streamlined procedure only on agreement. But of course, an institution like SIAC is in a better place to have an automatic application, which in UNCITRAL rules would be difficult.
From the client's perspective, when you're drafting the arbitration agreement, how realistic is it that they're going to include something like this in their arbitration clause?
I think at the drafting, the people say, well, we have to get over this quickly. The problem is when the dispute arises. You see corporate counsel, what they say at conferences or what they negotiate in the contract is something very different from how they conduct themselves or the case once the case arises, especially when they are respondent.
Jessica, Tom, anything you'd want to add?
I agree, actually. I agree, actually, at the drafting stage, it is very likely if one party is mindful of having either expedited procedure or streamlined procedure, because it is parties' autonomy. Parties can agree on anything. Remember, the SIAC, the institutional rules, is kind of the default setting. So parties can say, no matter how big my future dispute is going to be, both parties agree efficiency, time is of super importance to us. So we both agree to have to adopt the streamlined procedure. So all the decisions should be rendered within 3 months and no extension. I think that is something possible at the drafting stage. Parties can agree, and parties can even agree. So applying the expedited procedure, no matter how, be it, whether it's bigger or smaller, I think that's actually parties' full autonomy. They can agree to that. I think the benefit of having some kind of template clause is probably can encourage certain parties to consider this option at the drafting stage. Otherwise, as we all know, once a dispute really arises, the parties will have divergent views. So you wouldn't be able to reach any agreement very hardly.
Just to give the background, the drive in UNCITRAL came from a joint proposal of Israel and Japan, where they're saying our IT high-tech industry, they can't afford and they don't want to spend the time and money on an ordinary arbitration. They want something quick and dirty. So there is a drive from the industry of having these very short proceedings, especially if you look at startup companies in high-tech business, they simply say we have more urgent and more important things than to fight about disputes.
Yeah, I think Michael raises a very good point there. I think there'll be certain industries, the tech industry, as he mentioned in particular, where I think these streamlined procedures could work very well. And I completely agree with what both Michael and Jessica were saying about you're in a different boat at the drafting stage than you are. The parties are in a different boat at the drafting stage than when there's a dispute.
Absolutely. Another question that we've got on Streamline was that referring to something that Jessica mentioned when she spoke on this earlier, is that there were concerns when expedited procedure was announced regarding whether the parties had actually consented to that procedure. And so the question here is, did SIAC see any challenges to the expedited procedure on that basis, on the lack of potentially a lack of consent, did any of those challenges succeed, presumably at the enforcement stage?
I think that's probably a question for Kevin.
Jessica, I was actually going to say that might be a question for you, because I can only think of where an award wasn't enforced, but that wasn't because of the application of the expedited procedure. That was or the view of the Shanghai Intermediate Court on whether or not the tribunal was constituted in accordance with the agreement of the parties. I think that expedited procedure is getting more and more accepted. So you have two prominent decisions in Singapore, and then you have the decision of the Shanghai Intermediate Court that was somewhat context specific. So I think that we've gotten past that issue, but I think to the point of whether or not there should be a model clause, it's always better if you can get parties to agree to the expedited procedure, but it is somewhat less usable. And I think part of the reason why we've had almost 900 applications is because it does allow a party in a deal to see what the dispute looks like first, and then realize, okay, this is a relatively small dispute as part of this huge deal, so we are going to apply for the expedited procedure, because they may not contemplate that the dispute is going to be that small, say 5 years before at the time of transaction. So that's been a philosophical choice by SIAC. We think that it works very well, but certainly if parties want to agree, want to use a model clause, that is always better, because then you can't or doubt the fact that the parties have agreed to this procedure.
Kevin?
Yeah, and I see that SIAC has tightened the wording, the language of, the kind of default application or the application of expedited procedure, etc. So even if it is different from the parties' agreement, now the rules is clearer, saying as long as you accept these rules, that actually can be considered as you also agreed to, that unless you expressly disagree or object. I think that's actually something, make it stronger for parties to say, because there will always be arguments. I think we did have that discussion like last week in Shenzhen as to, because procedurally and also it is an important factor under the New York Convention as to parties' agreement as to the formation of the tribunal. So actually how to outright or override the party's decision in terms of the formation of the tribunal is something that needs to be dealt with very carefully and in a very, I think, clear way. And frankly, I think at the end of the day, I fully agree and support SIAC's decision and measures to make arbitration proceedings more efficient, because that's something I think the institution should care more. And it is more, and then at the end of the day, it should be depends on the attitude of whether the courts are more pro-arbitration or not. So it's, you can never, say there is no difficulty enforcing such kind of provisions, which is somewhat in violation of parties like provision on tribunal formation. But that is something I think, if it is always a balancing test, whether, for institution, it is more to advocate and promote efficiency in arbitration, because we all know parties will always have different views in different situations.
Yeah. Hey, Kevin, what are the problems you saw in your 900 applications with difficulties of the tribunal and the parties to handle their dispute in such a short period? I mean, you're not directly involved in the way how the tribunal deals with the situation, but you see, you probably see if there are difficulties of meeting the short period.
Yeah, I mean, sometimes the dispute can become much more complex than it initially appeared when we granted the expedited procedure. I think typically when we grant an extension, because there's two ways to deal with that situation. You can extend the 6 months, or we have the provision whereby the tribunal in consultation with the registrar can determine that the case will no longer be conducted under the expedited procedure. So when we are granting an extension, we tend to like to do it when it's based on the parties' agreed schedule for submissions. So the parties have agreed and they want additional rounds of submissions. What we don't want to have, which is why it's in consultation with the registrar, is the tribunal, for whatever reason, has just not been able to get to the drafting of the award, even though they say close the proceedings at 4 months or 18 weeks. That's when we don't want to grant an extension. But there's also an obligation on the Secretariat to remain in touch with the parties in the tribunal. So we want to know how the tribunal is doing at 3 months, 4 months, 5 months, so that we can make sure to get it there. But it doesn't happen too often, but it does happen.
That's the question. How often do you have applications for extension?
So it's not infrequent, I would say. Just pulling a number out, maybe in about I actually don't even want to confine myself to a number. I'm going to say
Chatham House rule.
Yeah. Because I was imagining myself overestimating it and then looking back at the data and seeing that I was way high. Not often, something that we want to avoid. And if there is an extension, we only want to grant a single extension. So if a 2-week extension or a 1-month extension is necessary based on the procedural calendar to which the parties have agreed, that's fine. If it's for any other reason, then we're a little bit less minded to grant that extension. But Michael, it's like what we talked about in UNCITRAL, is that you have to grant the extension. That's why you need to be liaising with the tribunal and the parties early, because you cannot have a guillotine at 6 months where the 6 month expires, no extension, and now the procedure is not in accordance with the agreement of the parties. So we have talked for many years about that when we were doing the UNCITRAL fast track.
But the request comes from the parties that are saying we can't, we need additional submissions, or it comes from the arbitrator who's saying this is so complex, we need, or I need more time to write the award.
Yeah, it comes from the tribunal, who will have liaised and consulted with the parties. So sometimes the parties will agree that an extension is warranted. So typically we want the tribunal to have already consulted with the parties on whether an extension would be necessary based on the procedural calendar.
Okay.
Thanks, Kevin. Thanks, everyone. Let's move on to another question. We have a question concerning coordinated proceedings and why it would be necessary if the parties could create the same effect with the assistance of the tribunal. Effectively, the tribunal already has the authority and the power to run coordinated proceedings. Why do we need a rule on it? And I actually think this is a bit of a theme that we discussed before this session, is that there are several proposed rules that just bring to the forefront powers that tribunals already have. And maybe Jessica or Michael or Tom or Kevin want to tell us sort of their views on whether this is a useful exercise. Anyone who has a strong view on it?
Okay, if I may start. I think actually this so-called, because we just discussed consolidation. Coordinated proceedings are different from consolidation, where 2 or more cases can be consolidated into one. Then you have one set of arbitration proceeding and one final award. The coordinated proceedings actually I think in practice are very practical as for all the practitioners, counsel and arbitrators, because there are cases where the standards for consolidation cannot be satisfied, or you don't have all the relevant consents where you can have consolidate the whole proceeding. But these proceedings, the several 2 or 3, let's say, arbitration proceedings really concern, same or similar facts, or similar parties, could be different parties, frankly. And for example, a series of transaction documents concerning the same project. And so there will be different parties and different roles, but actually many of the facts would be the same. The facts are the same, and the relationship and the issues would be the same. If all parties, of course, this is also subject to parties' agreement. And of course, I think why you specify or provide in the institutional rules, from my perspective, is at least something, a message you sent to the users, to parties, to say this is a possibility. And also remind the tribunal this is a possibility. Otherwise, you may have to conduct 3 separate hearings on the same thing. And you don't want one factual witness to testify 3 times. And because for the so-called due process of the proceeding. So I think at the end of the day, people will get more practical and counsel, even if how aggressive they are, how contentious they are. In terms when it comes to the hearing, I think many of the issues can be really sorted out, because for efficiency and also for the purpose not to repeating yourself and also to conflict yourself. And the coordinate proceedings also have the benefit to avoid conflicting decisions. And of course, I think I'm just thinking loud. It is not necessarily you probably only have the same tribunal members. It can also be possible, because I had two SIAC cases, like between two same parties, but two different joint venture disputes. And there are some joint common issues. And actually, the tribunal members are not identical. There are actually 4 arbitrators sitting in a room, listening and attending the hearing. So that's also something I think, as long as parties agree, those can be coordinated. That's my understanding of the practicality and the practical means and usefulness to parties. Because very often, I think from practitioners' perspective, I would need to at least to have the common chairman presiding arbitrator who understand the related cases, so not to avoid conflicting decisions on the same issues of fact and law.
That point of Jessica may require a change in 17.1, where it says the same tribunal. So the very interesting point that Jessica raised, you may want to allow different tribunals, and Jessica thinks the important part is that the chairman is the same. Then another question is, should it be the same parties? That is not mentioned. It could be different parties. Now, all of this can be organized by the tribunal, or if you don't if you don't have different parties, or you don't need an additional clause in the rules. A problem could arise if you have different parties, because then you have the question of confidentiality. Because parties, we're having now 2 parallel tribunals in almost the same contract, but separate contracts, and there is a strict separation. The arbitrator who sits with us in one case and also in the other has the obligation of not telling us what's going on in the other arbitration. Because so this question of confidentiality in coordinated proceedings may be a problem.
I think, Michael, I'm just, we're just, brainstorming. I think for this coordinated proceedings, because it is different from consolidation. So I think it can be more flexible, and the catch-all kind of provision is subject to parties' agreement. If all parties agree for practical purpose for having the hearing together, I think that is definitely parties' agreement can resolve the issue. And most likely, for example, even if different parties, there could be subsidiaries or related parties, and because there are basic same facts concerned or same legal issues concerned. So where the parties think it is necessary to just I think do the hearing together is more, I guess, for the hearing practicality rather than the procedural issues. I think that should be handled as they should be. But from my perspective, it's more likely for the hearing arrangement.
You would need a clause in the rules, or can that be left to the tribunal? Without I mean, the whole question I think we're discussing: do you need an article in the rules?
I think for me, it is actually, if you have an express article or provision in the rules, that is a clear message for the parties and for the tribunal to consider. Otherwise, for example, talking from the arbitrator's perspective, people might not be so willing to consider anything that has not been specified, because I understand different arbitrators have different experience level, and some may not want to try anything that has not been expressly provided for. I think that actually from that perspective, that should be a good encouragement for parties, for tribunal to consider.
The concern I have in putting in the rules is you fix a certain approach and a certain way of handling it and take it away from the arbitral tribunal. And that's a concern of putting it in the rules if you don't really need it. And for the rest, it's a question of educating the parties. And the question is, should the rules educate the parties or should there be different ways?
Tom,
At
you
last
also
year's
add-
SIAC symposium, Lucy Reed, the president of the SIAC court, referred to these provisions as spine stiffening provisions. They're not spine stiffening provisions. Kind of stiffen the spine of the arbitrator, give the arbitrator or the tribunal a little more confidence. You know, I think the person that posed the question is right. Strictly speaking, the parties can agree to these coordinated proceedings. The tribunal, in many cases, probably has the inherent authority to do this. But I think providing, as Jessica was saying, that procedural hook can be really important. And also keep in mind, too, that SIAC itself can nudge parties in this direction. If you've got two related cases, if there's a sole arbitrator, SIAC might appoint the same arbitrator in each case, and that can push the parties towards coordination. But I think having these provisions are useful.
Has it? Have you any experience with coordinated proceedings, Kevin?
I mean, lots, and that is the fundamental question. So tribunals are able to do it without the express authority to do it, and they do it anyway. But to Tom's point, and thanks for reminding me about the spine stiffening. I thought that was a great term. I think that the SIAC experience on early dismissal, I think, shows that by codifying a provision, you are going to get tribunals to use it more and have parties make more applications. Because even though tribunals can deal with claims at an early stage inherently, once we put in the specific early dismissal provisions, it started being used much more. So that's kind of that's an overall question for us that touches on not just on coordinated proceedings, but on some of the other proceedings, like getting very specific on preliminary determination, which we don't have time to deal with today. Is that going to make parties use it more and give tribunals the confidence? And then ultimately to the faraway enforcement court as well. They may want to see that in the rules to see that the tribunal has power to do this.
Great. Thank you all. Unfortunately, we are out of time, so we're going to have to wrap this up. To those of you whose questions we didn't get to answer, I apologize. But if you have feedback you'd like to share, please do share it you can go on to the SIAC website, and there's instructions for how you can submit your feedback to the draft rules. We'd be very grateful for the feedback of you and all our users. And we're very grateful for this session today, to have the views of Jessica, Michael, and Tom, and of course, Kevin. Thank you all very much for being here. Unless you have any final parting words for the guests, I think we can just go ahead and wrap it up. All right. Thanks, everyone. Have a good evening.
And thanks to our chair.
Thank you.
So, thanks, Michael.
Bye.
Thank you.
Bye-bye.